Good afternoon, everybody. Thank you for joining us. My name is Brian Zimmet. I'm a partner here at Venable. I'm a regulatory lawyer. I specialize primarily in energy regulatory work with a subspecialty in cybersecurity regulation. And today we'll be presenting a webinar on managing liabilities from cyber threats using the Safety Act. Just a few preliminary notes. All of the lines on this webinar are being muted. So if you have a question, please use the chat box on your computer screen. When you have questions, you can type them in. We will. Our plan is to answer questions at the end of the presentation. So the questions that are asked will be answered at the end. And also, please note that just so you're aware, this webinar is being recorded. So and the recording will be posted on our website, as will all of the materials, the presentation materials from the webinar. Okay, so just to get started and to introduce the topic, as I think most of you know, cybersecurity has gotten a lot of press lately, a lot of attention from policymakers and regulators, and to start at the beginning, sort of the very, very basics. Most of modern life these days is run by or run in conjunction with, facilitated by computer networks. And computer networks run pretty much everything, or almost all aspects of modern life, from the electric grid to bank transactions to the air traffic control system to traffic lights to the way that you program the HVAC system in your house, So the security of these networks has become a major governmental concern. And unlike the provision of physical security, where the government has an army and police forces and can secure the physical borders of the homeland, if you will, security of computer networks is much more difficult for the government to provide when those networks are not in government hands, when they're in the hands of private entities or non-governmental entities. It's much easier for an adversary to attack a computer network, to reach across the internet and attack a computer network than it is to conduct a physical attack. And so the government, especially in the last couple of years, has developed a much stronger interest in seeing computer networks protected adequately, and has taken certain steps to try and encourage the protection of those networks. Now, some industries out there are actually subject to mandatory federal cybersecurity regulation. I mean, these are industries where the government has been given regulatory authority by Congress and has exercised that authority to prescribe cybersecurity standards and has the authority to punish entities that do not conform their practices to those governmental standards. The most notable area so far is the electric utility industry, which is subject to mandatory federal cybersecurity standards. Most areas of the economy, however, remain outside of or are not subject to, at this time, federal cybersecurity regulation. And there is a lot of debate going on in Congress over whether other industries should be subject to that regulation. But to date, Congress has not yet passed any legislation that would subject most other industries to mandatory cybersecurity regulation. So the Obama administration has taken certain steps to try to encourage or promote stronger cybersecurity practices on the part of entities that are not themselves subject to mandatory cybersecurity regulation. The most notable step the Obama administration has taken was the issuance of Executive Order 13636 in 2013, which resulted in the development of what is known as the Cybersecurity Framework by the National Institute of Standards and Technology, which came out, the final version of that came out at the beginning of this year. And the purpose of that framework, again, is to try to encourage the use of at least certain minimum cybersecurity standards on the part of entities across the spectrum of what are known as critical infrastructure industries. So we're talking about, in particular, the oil industry, gas industry, transportation companies, certain manufacturing companies, water companies, banks, hospitals, any industry, the disruption of which could substantially impact the quality of American life in a significant way. Now, the adoption of the cybersecurity framework has, I think, only heightened the potential liability risks associated with a failure of an entity to adequately defend its computer network. The failure to adequately defend such a network always gives rise, will always give rise to potential liability risks. That's not new. But the development of the NIST framework has made it easier, has I think sharpened those liability risks, because it's making it easier to define the standard of care that a company will be held to in its practices defending its computer networks. And that gives rise then to the question on the part of a lot of companies, which is, how can I best manage this risk? And that's the topic of today's webinar. One way to manage that risk is through the use of the Safety Act, which is a statute that is administered by the Department of Homeland Security, and as my colleague Dismas Locaria will describe, provides certain substantial liability protections for the development and adoption of what the statute describes as anti-terrorism technologies. Now, the term anti-terrorism technologies is defined broadly by the statute to mean not just actual technologies, but services as well. And the Department of Homeland Security, in looking to promote the adoption of the NIST framework and of stronger cybersecurity practices in general, has started to allow the use of the Safety Act to cover a company's own internal cybersecurity programs, which which it uses to defend its computer networks. This is a relatively new and somewhat novel application of the Safety Act, but it is nonetheless a real one, and it is one that companies, entities who, that entities are able now to take advantage of. And that is what we are going to talk about in more depth today. So with that introduction to the background, let me turn the presentation over to my partner, Dismas Locaria.
Thank you, Brian. My name is Dismas, or Diz Locaria, and I am a partner at Venable, government contracts lawyer by training, but also have played in the Safety Act area for the better part of 10 years now. As Brian mentioned, the Safety Act grew out of the Homeland Security Bill of 2002 following 9/11. And the Safety Act is a very poorly constructed acronym for Support Anti-Terrorism by Fostering Effective Technologies Act. And that, the concept of the Safety Act was that it was intended to encourage the development and deployment of what Brian pointed out was called anti-terrorism technologies by creating certain risk and liability tools for entities to manage the risks that might be associated with bringing certain technologies to market, or in the case of existing technologies in the marketplace, allowing those technologies to exist and proliferate in the marketplace. But the term technologies is a little bit of a misnomer because it gives folks the impression that it applies to physical devices, and that's certainly one area of Safety Act coverage, are products, devices, and equipment. If you go to an airport, for instance, a lot of the items you see at the security check-in at an airport are Safety Act covered technologies, X-ray scanners, metal detectors, all of those types of things. Many of those have been through the Safety Act process. But services, as Brian mentioned, is also covered by the Safety Act. And when you talk about services, the statute was originally designed to cover support services. It was only useful to have a technology brought to market if that technology is maintained, and if a company is required to maintain that technology, certainly there's associated liability if that maintenance fails for whatever reason. Well, they decided to cover support services for those technologies, but then before the act was finalized, it was extended to standalone services as well, which has carried on to guard services and certain other types of security services that you can think of. But also, as my colleague mentioned, it has now, with the new emphasis and concern related to cyber-related terrorism, it is certainly applicable to cyber-related items, which would include, information technology, security components, networks, integrated systems. The security that's put in place to protect these systems is absolutely a Safety Act technology. So what does the Safety Act do? We've talked a little bit about anti-terrorism. So the scope of the act is that it applies to an act of terrorism, which may include cyber terrorism. An act of terrorism is defined by DHS as having three parts. It's unlawful, it causes harm, and that harm can include financial harm, and that harm needs to be to a person, property, entity within the United States, which does give some extraterritorial application because oftentimes persons, property, entities of the United States are abroad, but the harm is exacted against that entity, and that entity is of the United States. So it does have extraterritorial application as well, and that it is the result of an attempt to use instrumentalities or weapons designed to cause mass destruction, injury, or loss to citizens and institutions of the United States. So that's kind of a threshold requirement. that it applies there. Now, the regulations provide specifically that it's not limited to foreign acts of terrorism, but domestic acts of terrorism certainly qualify. And as I mentioned, it does have extraterritorial application depending on U.S. interests overseas. There are 3 levels of Safety Act protection, and we'll get into each of these in more detail. The two of the levels are created by the statute, designation and certification. Designation is called the lower level oftentimes, and certification is kind of the higher level, and we'll get into the differences primarily around what's required and then also the benefits. But the regulations also recognize a need for what's called Developmental Testing and Evaluation Designation, DTED. And DTEDs are important because oftentimes entities are trying to bring to market a technology that's not yet proven effective. And as we'll talk about, efficacy is a major criteria for designation and certification. And when you're bringing something new to the marketplace, you may not have enough data or enough history to demonstrate efficacy. But absolutely, if it's in a testing environment, you need to have protections. Otherwise, you may not even want to test it because the liability can be so great. So they did create this DTED designation for newer technologies that may not yet have the full panoply of data that might be necessary for designation or certification. So what are the benefits of designation, certification, and DTED? Well, I put certification at the top because that's the one that most folks are most interested in. It includes all the benefits of designation, but it includes what's also called the government contractor defense, and I'll talk about that in a second. Designation includes a host of different things, such as exclusive jurisdiction in federal court, consolidation of claims, punitive or prejudgment interest. So those are significant benefits, but the one that folks are most focused on usually with designation is a cap on your liability at a predetermined level of insurance. And what that essentially means is that organizations can plan. They can plan for the worst case scenario. Whereas in 9/11, the worst case scenario was unfathomable prior to 9/11, and the liability was disastrous, tens of billions of dollars, most of which companies could not insure against. But designation does provide companies with a liability cap that they then can predict against, and they can charge certain rates for their products and services. They can take many different measures that can let them predict for that type of situation. Now, certification, as I mentioned, has all those benefits of designation, including that liability cap, but more importantly, it has what's called the government contractor defense, which is a defense that's judicially created that provides sovereign immunity to government contractors when working for the federal government. Essentially, it extends this defense to Safety Act certified technologies, essentially saying that you are immune from liability in the event of an act of terrorism. That obviously is a huge benefit for companies because not only can you predict against insurance losses, but in fact you would have no losses in the event of an act of terrorism. So as I first set out, the idea of the Safety Act, the concept of the Safety Act was to foster and to encourage entities to bring to market not only items for sale, but bring to market internally security measures to better the country as a whole. And certainly certification provides that benefit, as does designation. DTED provides the same benefits as designation, but it's usually for a shorter period, and it's usually limited to certain deployments. It's not as widely applied typically. They typically apply it to test cases, wherever the beta test might be occurring. To obtain Safety Act protections, obviously these benefits are significant, and there is a process by which one needs to go about in order to obtain Safety Act certification. Now, designation is where the primary, or at least the predominant number of criteria lie, because in order to obtain certification, one must have designation. That doesn't mean it's a two-step process. You can apply for both at the same time, but you need to address all the factors of both designation and certification. So designation, it requires essentially a showing of 7 factors. One, that it's demonstrated substantial utility and effectiveness. Efficacy is number 1 on the list there. Availability for immediate deployment, that it protects against things that would have extraordinary large or unquantifiable third-party liability risk, that there's a substantial likelihood that without designation, the product, service, technology may not be deployed at all or in the same manner or as widely distributed, that there's an impact. It's essentially a but-for test, that there's an impact that if Safety Act's not extended, the public or an entity would not be deploying its protections as much as it could otherwise. That the magnitude of the risk is significant if it's not deployed. That there are studies that demonstrate that it works to reduce harm, and that it's essentially, again, there's a kind of a repetitiveness here. It's essentially that it's effective for doing what it's supposed to do to defend or prevent or respond to terrorism. So those are the criteria of designation. Now, DTED follows many of those criteria, but not all of those criteria, because as I said earlier, DTED designations are not, the same standard of efficacy is not necessary. And so those criteria that apply to efficacy and to immediate deployment are not the same types of standards for DTED. Now, certification requires that you meet all those designation criteria, and then that you also are able to satisfy certain additional criteria. And these are somewhat tricky, but that the technology performs as intended, that it conforms to your specification, and that it's safe for use. So those 3 additional criteria must be met. Essentially what this boils down to with the Safety Act Office is that designation needs to be proven effective. Certification, there needs to be some kind of effectiveness plus, that you have to really go out of your way to show a high degree of efficacy and demonstrate that to the Office of Safety Act Implementation. So to obtain Safety Act protections, one must go through an application process. More and more they have entertained the idea of on-site reviews, and they certainly are open to oral discussions. But at the end of the day, the application needs to be supported by written materials. And so you need to go through an application process. Now there is an optional pre-application process that allows you to propose your technology and see if it's applicable, if there's a likelihood of success based upon kind of your current status and the current data and information that you have available. And they have 21 days to review that and provide feedback. But the pre-application process is not necessarily required, and oftentimes you can kind of skip this step and just see if you can even talk with the Office of Safety Act Implementation about the applicability of a certain technology or the likelihood of your success based upon where you are. Once you've gone through the pre-application process, there's a standard application process that you have to go through. And typically, the way we view this is that you start off doing an internal assessment, that you need to identify the standards and documents and information that you have that meets those criteria. And if you have any shortfalls anywhere, you need to consider enhancements or improvements that can bring you up to what's going to be required by the Office of Safety Act Implementation. Then you prepare the written application. They can be extensive at times. I've worked on applications in excess of 100 pages with in excess of hundreds of attachments. because of the amount of information that's required. And then you submit that application to the Office of Safety Act Implementation. So what goes into these applications? Well, we talked about the criteria, but how does that really boil down to what they're looking for? Well, I've tried to break it up here to make it user-friendly based upon products, services, and programs, but there are some factors that are the same across all types of applications. First, you have to register with OSAI. You have to provide certain points of contact on administrative matters and subject matter expertise, as well as financial and insurance information. You need to absolutely have customer references that they may chat with. Always good to double check with your references that they are in fact positive references. Believe it or not, that does still happen, that folks have references that aren't necessarily positive. Always good to give them a heads up of the information that the Safety Act Office is particularly interested in, and preparing them for those phone calls or emails. You have to have a description of your technology. In other words, you need to be able to write clearly, intelligibly on a piece of paper what it is that your technology does. You have to address safety issues, have information on those issues. You have to have information on your insurance and your financials with respect to that technology. That can be sales data. Sometimes that's easy to derive. Other times, depending on how organizations are set up and what type of technology it is, that can be more difficult. So those are all pieces of information that are absolutely required for all applications. Now, for products, in my experience, some of the pieces of information that you'll want to know in order to put together a product type application. When I say products, I mean tangible items, X-ray detectors, metal detectors, those types of things. You need to be able to talk about what the product components are, the subcomponents, and break it down. A lot of times they're going to want to know who are the manufacturers of all those components and how those manufacturers have been vetted, and ensure that the subcomponents and the components meet certain quality requirements. What are your quality control requirements for your subcontractors that feed into the manufacturing process? What is the manufacturing process, and how is that controlled? How are items that are coming off your assembly line tested, and what is the failure rate? What is the infant mortality rate for those items? Those are a lot of the types of things that they're going to want to know. Then they're also going to want to know, what is your deployment strategy? Is it something you sell, or do you lease it? And if you lease it, do you then provide maintenance services as part of the lease? And if you sell it, do you provide maintenance services separately, or does it come with the sale? Those are all things that not only OSAI wants, but if I were preparing your application, absolutely things that I'm interested in, because we want to make sure an application is as broad and as encompassing as possible to ensure you're protected. It's one thing to sell a widget and say this widget is covered. It's another thing if you're maintaining that widget and that maintenance service is not covered. Well, plaintiff's lawyers are going to go after whoever's available to pay the bill. And if the manufacturer is covered, but the maintenance services are not covered, it leaves a gap and it leaves exposure. So we want to make sure we fully understand the deployment strategy. With respect to services, services can be a lot more trickier than products, because essentially you're talking about a human interplay here, and so a lot of it goes towards that human element. We need to know information about how you recruit your employees, how you hire them, how you train them, what type of initial, but also the recurrent training. It's not sufficient to train someone out of the gate necessarily, and then 10 years later expect them still to perform up to par. So it's about the recurrent training. What kind of policies and procedures are those individuals subject to? Is that documented? Do they have post orders? Do they have some type of operational document that is imposed on them? And then quality control, similar to manufacturing. What type of oversight, quality control, quality assurance efforts are in place? And again, similar to products, are you using subcontractors? And if so, what type of vetting process do you have? Do they have similar recruiting and hiring practices? Do they have similar training practices? Do they follow yours, or do they follow their own? And if they follow their own, is that sufficient? Moving on to the next category, programs. So here we're talking about things like a cyber program. Well, as my colleague Jason Wool will explain in a few minutes here, this is all about developing baseline standards for adherence and how you go about implementing against those baseline standards and how you oversee your adherence to those standards. And so, again, it's going to be a paper-based approach, and we have to be able to support all of this through documentation. And some of the documentation will be narratives that we draft, but a lot of that needs to be supported by underlying documents that are company documents that stipulate that these policies and procedures, et cetera. So every statement we make is supported by a document. And as I mentioned, a lot of times, as we go through this process with clients, there are gaps, there are shortcomings. We might not have a document that details, background checks or things like that a company has, and so we have to make enhancements or develop documentation, and that's not unusual. So once you've gone through that process and developed the application, enhance the application as necessary, you go ahead and submit the application to OSAI. Well, they have, by regulation, 120 days to act. The first 30 days, they'll get back to you and respond whether the application is complete or not. And what that means is, do they have sufficient information to make a determination? Now, they have a very tight 120-day turnaround, and so what this has created is a little bit of back and forth at the completeness stage. Because if there are too many kind of deficiencies in an application or holes, or they have too many questions, they will incomplete an application inside that 30 days. They'll provide a letter that outlines everything, and then it's without prejudice, which means you can resubmit when those items have been addressed, and then file again. And so sometimes there is a back and forth, because if you don't have that upfront dialogue, you may not know exactly what it is they're concerned about or what they're looking for. Again, oftentimes that, to avoid kind of the back and forth on the completeness stage, that upfront dialogue is sometimes very useful. But after the 30 days, they will go into a technical and economic review of the application, and that means they're looking at both, the technology itself, but also the insurance and financials to determine what that preset level of insurance might be. And through this process, they may have additional questions and ask for additional information, and so they will issue RFIs. And RFIs usually have about 7 to 10 days to respond. You can sometimes get an extension, but because it doesn't extend the 120-day clock, it is something that needs to be turned around, usually no longer than 2 weeks, because they just have a very tight timeline, and so they expect you to respond very quickly. Now, if it's something that is impossible to respond in that period of time, what they may do is they may reject your application without prejudice, ask you to go, check those boxes and resubmit once that's done. After the 120 days, it goes to DHS for a decision, and a decision letter will be issued. Now, some important aspects about the Safety Act is that, we've talked a lot about its applicability to anti-terrorism, but in in just recent days, this bill has been percolating for a little while, but just recently the House passed what's called the National Cybersecurity and Critical Infrastructure Protection Act of 2013, and essentially what this does is it amends the Safety Act to add what's called a qualifying cyber incident as a trigger for protections under the Act, in addition to acts of terrorism. What this means is it does not require the act to be necessarily an act of terrorism if it's a qualifying cyber incident. Now, as I mentioned, the House just passed this. Congress is going to be going in recess, and so we're not certain whether the Senate will pass it or whether the President will sign it, but it is a recent development in the Act. One other benefit of the Safety Act before I turn over to my colleague Jason is that it also applies whether you have designation or certification. An important benefit is not just the protections that you receive, that the applicant receives, but also that your customers receive actually better protections. Under designation, where your liability is capped at insurance level, your customers will actually receive immunity from liability. And similarly, under certification, you're receiving immunity, they will also receive immunity. And the reason for that is the Act was written in a way that provides that the only proper party defendant to an act of terrorism, terrorist liability resulting from that technology, is the quote-unquote seller of the technology. And by seller, they mean the entity that is either selling it, or if it's an internal program or process that a company has, they're essentially selling it to themselves. And so the only proper party defendant is that entity, meaning all the customers and users and contractors and subcontractors up and down the supply chain are actually immune from liability, even under designation. And we've seen this be a significant benefit for our clients because it's just an absolute market differentiator for these services. So with that, I do want to turn it over to my colleague, Jason Wolf, to talk a little bit more about the Safety Act and its application to cybersecurity.
Thanks, Diz. And just to give a brief introduction of myself, my name is Jason Wool. I'm an associate here at Venable in the energy group, and I focus primarily on cybersecurity in the electric sector and in other critical infrastructure sectors as well, along with Brian Zimmet. As Diz explained, the Safety Act, as he just mentioned, covers qualifying products and services that are made or offered by sellers, as they're called. But the language of the statute is broad enough that a seller can obtain coverage for a technology or a service that it provides to itself, such as its internal security program, both physical and cyber. And of course, that's why we're here today. In the case of security programs, because they're a service, it's often necessary to choose a set of standards on which to model or base the program, also as Diz mentioned. Doing so provides a baseline against which the seller or applicant can measure and compare its practices to demonstrate that it meets certain criteria that have been deemed to be necessary by the standard-setting organization. That's important specifically with regard to programs because it's just with the requirement or the required showing under the statute, it's a little bit amorphous when it comes to a program. So you need to sort of provide something that you can compare the program to. So in turn, this allows the seller to corroborate that the security program is effective, which is one of the most important parts of the application, and that it's reasonably designed. Again, those are difficult to show without something external to the program that can be compared to. And this is especially important in the cybersecurity context in particular. If an organization opts to implement a set of standards, controls, or guidelines, the question that comes up is which one to use. In the context of the Safety Act, there's currently no set or preferred cybersecurity standard for security programs, and this is because the use of the application, I should say, of the Safety Act to cybersecurity programs is still in its infancy. So the Office of Safety Act Implementation, or OSAI, as I'll be calling it, is actually, as we understand it, currently working to develop a standard methodology for reviewing cybersecurity applications, which would include perhaps, we're not sure, but perhaps a set or a list of preferred standards or guidelines. We don't know at this point what that methodology would look like. But because we're so early in this process, there isn't any preferred standard that can be used, or that should be used, I should say. So a number of options exist as a result. NIST Special Publication 800-53, ISO 27001, COBIT 5, the top 20 critical security controls. These are all well known and well regarded, and you'll find all of them listed in the informative references section of the NIST Cybersecurity Framework. And those are of general applicability, but specialized options exist as well. For instance, industrial control system users may want to consider incorporating guidance from NIST's special publication 800-82, which specifically focuses on ICS systems, and that would be in addition to 800-53, for instance. The main criteria that organizations should use when selecting one of these standards or guidelines is the reputation and the level of acceptance, as well as regulatory obligations and the availability of industry-specific guidance. So, for instance, let's say you're in the water sector, there are sets of cybersecurity standards that are specifically geared towards the water sector, and that might be a good choice. For entities that are regulated with regard to cybersecurity, such as the electric sector, regulations can serve, our understanding is that regulations can serve as the basis for a set of standards that will be used as the baseline, but our understanding is that OSAI may expect additional measures to be included in the program. Fundamentally, the reason for this is that OSAI does not view compliance with mandatory regulations on its own to be sufficient to warrant coverage under the Act. To be clear, regulations can serve as the foundation of a program for which a regulated entity seeks coverage, but the program may be required to exceed the requirements of those regulations. In other words, in this context, OSAI would be looking for something that we will casually refer to as regulations plus. Conversely, for entities that are not regulated or that have assets or systems that are not subject to cybersecurity regulation, the use of cybersecurity regulations may be sufficient to obtain coverage. Whichever standards an entity opts to use as its baseline, we're highly recommending approaching OSAI with a proposal before submitting an application in order to determine that the proposal has any facial flaws that could prevent coverage from being extended. And that's what Diz referred to earlier as the pre-application process, which has a 21-day turnaround. The OSAI's review of Safety Act proposals is time-consuming and resource-intensive within 120 days, as Diz mentioned, and applications that contain a fatal flaw must nonetheless be studied carefully. And perhaps more importantly, the preparation of an application is also time and resource intensive on your end. Therefore, we highly recommend that if you're seeking coverage of a cybersecurity program, or a physical security program for that matter, consult the office and inform them of the facts to provide a summary of the proposal and see what they say about that before going ahead with the full application. That said, we can provide some basic guidance to cybersecurity applicants regarding some of the key features that OSAI expects to see in cybersecurity programs that are included in applications. In general, OSAI is looking to provide coverage to programs that are of a quality that puts them at or near the top of their respective industries. The program should demonstrate a strong commitment to security throughout the enterprise, as well as substantial investment in technologies, personnel, and other key resources. Finally, the program should demonstrate significant maturity, meaning strong controls, continuous improvement, and sophisticated capabilities. In other words, programs that are only minimally sufficient may not be eligible for coverage. And here, what you're looking at, these are two examples of Safety Act protections for cybersecurity and security programs that have already been granted coverage under the Act. So the American Chemistry Council received coverage for its responsible care program. We know for sure that that includes a cybersecurity component. Another example that we've shown is Bank of America. The description of that technology is not clear as to whether it applies to cyber, but our understanding is that it includes a cybersecurity element. Okay. onto the NIST Cybersecurity Framework. Although it does not itself include standards, controls, or guidelines, the NIST framework is a recommended component of a cybersecurity program being submitted for Safety Act coverage, especially for owners and operators of critical infrastructure. As Brian mentioned, it was developed in response to the executive order from 2013, and the framework itself is a risk management framework designed to assist implementing entities to make cyber risk management an integral component of enterprise risk management throughout the organization. It is designed to be both flexible and scalable so that organizations of all sizes and maturities and with differing business models and needs can implement it. The framework core organizes an array of outcome-focused security practices into 5 overarching functions: identify, protect, detect, respond, and recover, and allows the user to plug in whichever controls or standards it likes to accomplish each applicable security goal. In mapping a cybersecurity program to the framework and implementing the gap assessment methodology and risk management model, an organization can more easily visualize both its current and desired future state in terms of practices and maturity, as well as communicate with other entities about cybersecurity more fluently, including stakeholders, suppliers, and contractors. The framework is a great fit for any organization that seeks Safety Act coverage for a cybersecurity program for a number of reasons. The OSAI is part of DHS, the same agency that's responsible for administering the framework through what's called the C-Cubed program. As a result, it seems logical that the framework would be viewed positively as part of an application. The framework also features what are called tiers, which are a standardized maturity indicator that can be used to assess and then express an entity's programmatic maturity. Given that OSAI, as mentioned, is looking for highly mature programs, it behooves any applicant to express its level of maturity in a way that is easily communicated and understood. Finally, a key goal of the framework is to allow entities that implement it to assess their current cybersecurity postures vis-a-vis their desired postures. This can be particularly helpful to an entity as it attempts to determine whether its cybersecurity program would likely to be approved by the OSAI. And I'm going to turn it over to Brian Zimmet for this slide.
Well, so we are, thank you, Diz and Jason, and just to close out the presentation part of the webinar, before we get on to questions, how we can help slide. I mean, really, the Safety Act application has essentially 3 parts to it. One is conducting an internal assessment of an entity's cybersecurity program to see how it matches up against applicable standards, and whether it's feasible to go in and actually seek Safety Act coverage. And that phase also involves basically trying to bring the entity up to the minimum level that would be required to obtain that coverage before actually going into OSAI for consultations and a formal application. Phase 2 would be the sort of pre-application process with OSAI, going in, talk to OSAI, engaging with them, engaging with the staff there to talk about the applicant and the applicant's program, and to sharpen or figure out what it is exactly that OSAI will be looking for and focusing on when the application comes in, and then adjusting the application to kind of fit those or address those concerns. And then phase 3 obviously is the production of the application itself and its submission to OSAI. And then just to conclude, again, this is a new application of a relatively new application of the Safety Act. But as I mentioned at the beginning, it's not any less real for being new. It provides a lot of Safety Act coverage provides a lot of concrete benefits to businesses, even apart from the actual liability limitations under the statute. And we have found on behalf of some of our own Safety Act clients that it has lowered their insurance premiums. And insurers obviously are more willing to provide lower premiums because there's defined liability when a business has Safety Act coverage for its own programs. In addition, government approval of a security program, even apart from the liability limitations under the statute, it sort of serves as you can think of it as a DHS stamp of approval for your internal cybersecurity programs, which in the case of a lawsuit can be very helpful in pushing back against claims that an entity violated its standard of care. And then finally, as Diz mentioned, it can serve as a market differentiator between different companies, because not only does the entity that obtains the coverage, not only is that entity covered, but its customers are covered as well, and their liability is similarly limited. So then, just to conclude, there are, as with any other area where the government decides that it has a vested interest in seeing people behave in a particular way, there are basically two ways for the government to get entities to adopt cybersecurity practices that they want to see. One is through mandatory regulation, where the government prescribes standards and then threatens to bring the weight of the government down on them if they violate those standards. There are some segments of the economy that are subject to those kinds of regulations, but most are not. The second way is to provide incentives or benefits, and that's really the regime that we're in right now. Most segments of the economy are not subject to mandatory cybersecurity regulation, but there are risks of liability, tort, and breach of contract liability associated with not adequately protecting computer networks, and the government is offering this carrot to entities that bring their cybersecurity programs up to an acceptable or adequate level. With that, that concludes the presentation portion of the webinar. We'll be taking questions via the chat function on your computer screens.
Mm-hmm. I'm going to read some of these questions out loud. Also, I just wanted to mention that with regard to the internal assessment that Brian mentioned, that of course engaging counsel to do that would help to ensure that those communications were privileged during that internal assessment, which is an important consideration. One of the questions we've got here is, how does the Safety Act lower premiums if the liability is capped at the insurance? Diz?
Sure. So what we've seen, and then what we've heard anecdotally. What we've seen is clients that have received certification, which again is that higher level that has immunity, has had their premiums reduced, because while they're still required to carry insurance because designation is a prerequisite to certification, insurance companies and some of the more savvy insurance companies and brokers that are aware of the Safety Act recognize that even though they're carrying X amount of insurance because they're immune from terrorism liability, there is real value there. And so we've actually seen clients have their premiums reduced by more than our legal fees because they have certification. Now, we've heard anecdotally that clients have also had insurance premiums reduced even though they only have designation or even just applied for designation. And what I'm speculating on that front, I'm not the insurance provider there, is that the stamp of approval, as Brian was talking about, the DHS stamp of approval is worth something. Here you have a federal entity that has gone and vetted your technology and said it works. And that means something in the commercial marketplace. And so we've seen or we've heard of entities obtaining insurance reductions because of that. So that's what we know on that front.
And another question that we received, Diz or Brian, what role would a third-party assessment of a company's cybersecurity program have, and would a third party be necessary for that?
In my estimation, a third party is helpful because, you're saying, I guess the question goes to a third party assessment in combating a liability lawsuit of some kind of negligence or lack of standard of care. I think if you have the federal government saying what you do, your program, it's effective, I think that certainly rebuts an argument that you were somehow negligent or didn't have the requisite standard of care in place.
Yeah, and I think if the question goes to a third-party assessment, is that needed to establish to OSAI that you have an adequate program, it can be helpful, although I don't know that it's absolutely necessary. But it can be helpful in making that showing.
Right, agreed.
And we have 2 minutes left. Do we want to answer one more question?
Sure.
Let's see here. A few of them are coming. If we don't get to your question, we'll respond to you and follow up afterward. Well, this is a real simple one. Are you aware of any cases of Safety Act application?
To date, the Safety Act has not been invoked. I've talked with the director. I talk to him frequently at the Office of Safety Act Implementation. Indeed, there has not even been a request to date for the invocation of an act of terrorism for Safety Act purposes. So it is not tested in that regard.
Okay. And we have 1 minute left. Last question, again, we'll follow up if we don't get to your question here, but would it be unlikely for a SCADA system that simply operates infrastructure to qualify under the Safety Act? I think the answer to that is pretty simple. It's not about the fact that it's a SCADA system. It's about what sort of program you're putting in place to protect the SCADA system. Yes. So if you're putting in a very sophisticated cybersecurity protective system for that SCADA, that would be ripe for consideration by the OSAI. Whereas if you put in minimal cybersecurity protections for a SCADA system, that maybe wouldn't get the coverage. But the fact that it's a SCADA is not determinative.
Yeah, in fact, I think their SCADA systems most definitely would qualify if they are adequately protected.
So it's 1 o'clock.
With that, I think
Yeah, I think we've run out of time.
We've run out of time. As Jason mentioned, if we did not get to your question, we will contact you separately with an answer, and we will post the materials and a recording of this webinar on the Venable website. And we will also post all the questions and the answers that we provide to those questions that we haven't gotten to. Thank you all very much for joining us today. We will potentially repeat this webinar again in the fall for anybody that may have missed it. Thank you very much and have a good afternoon.